David asked me to give my approach to an English law approach to slavery and trafficking. So I'll start with Somerset's case. So in 1772, there was a fugitive slave called James Somerset, and he forced a decision by the UK courts as to whether or not slavery was permitted or outlawed under the common law. Now, by that time, African slaves were being brought into the UK, into England. They weren't being sold, but their presence was clear. There were no rights to naturalisation. Now, in this case, Somerset was accosted by his owner, his master, and he was captured and imprisoned on board a ship due to set sail to Jamaica, where he was to be further enslaved. Actually, in the meantime, he had been baptized in London and had some godparents, and they set about having a writ of habeas corpus to have him released, and that's how the case came to court. In his judgment, Lord Mansfield declared that the state of slavery is of such a nature that it's incapable of being introduced on any reasons, moral or political, but only by positive law. Whatever inconveniences, therefore, may follow from a decision, he said, I cannot say this case is allowed or approved by the law of England, and therefore James Somerset must be discharged. He was free. So judgment was establishing that under the common law there was no entitlement to hold someone as a slave. And what we then have following after that was a lot of slavery-related legislation. By the Slave Trade Act of 1788, this was the first piece of legislation to determine what was going on in the slave trade, and this was about respecting more the conditions of the slaves on board the ships rather than abolishing slavery. In this case, it regulated the number of people that slave ships could transport. Dobbin had been a member of Parliament who had gone on board a ship to see the conditions that the slaves were being held in, and there was an extremely high mortality rate because of illnesses and overcrowding and disease. And so that act was the first to impact on the slave trade at all. The abolition of the Slave Trade Act of 1807 then followed. This abolished the slave trade in the British Empire, particularly the Atlantic slave trade. It didn't itself abolish slavery. That was abolished some years later by the Slavery Abolition Act of 1833. Important to note here was that the Act also encouraged British action to persuade other European states to abolish their slave trades. What was the enforcement of someone being found to be trading in slaves in the British Empire? It was a fine of £100 per slave. And what did this lead to? This did lead to captains dumping slaves overboard when pursued by the Navy. The Slave Trade Felony Act followed in 1811 in realising that the imposition of a fine wasn't really going to cut the mustard here. It was decided that probably something more serious in terms of sentencing would be appropriate, and a death penalty was actually brought in, which was changed a few years later to a sentence that was called transportation. Transportation was actually taking the convicted person to a penal colony where they would be for the rest of their life. It was a life imprisonment that was imported. The Slave Trade Act of 1824 was also involved in further consolidating the laws on slavery, and the Slavery Abolition Act came in 1833, which finally abolished slavery throughout the British empire. This came about through a lot of the campaigning work of William Wilberforce, who you'd have heard of. It took him 20 years to get this act passed, and the Anti-Slavery Society was formed, which was the campaigning organisation behind the drive for this, which in its current form is Anti-Slavery International, based in London, and the world's oldest human rights organisation. The Slave Trade Act of 1843 extended provisions of the Slave Trade Acts. Until then, the bite, the clause of the machinery was in respect of a slave who was captured and detained. But what about those who were under bonded labour? Interesting to think about our modern-day slavery. It was recognised under the Slave Trade Act 1843 that all of the criminal offences relating to slavery should so too apply to those who were bonded through servitude and owing to debts imposed upon them. The Aberdeen Act of 1845 was an interesting one. This permitted the Royal Navy, it related to Brazil, and permitted the Royal Navy to stop and search any Brazilian ship suspected of being a slave ship on the high seas and to arrest slave traders caught on the ships. Finally, the Slave Trade Act 1873 was the last piece of legislation, and this clarified the laws again and included more powers to stop and search. Where are we? Well, tackling modern-day slavery in the UK, we were bound by the European Convention of Human Rights from the time of its signature in the 1950s. Article 4 always included a prohibition on slavery, servitude, forced and compulsory labour. We brought that into direct effect in the UK under the Human Rights Act 1998. The first internationally recognised definition of human trafficking arose through the Palermo Protocol, as it's known, 2000, the UN protocol. It's based on the 3 Ps approach. What was realised is that human trafficking was growing, becoming one of 3 most prolific black market trades in the world. You all know this: arms, humans, drugs. So the idea to combating human trafficking is very specific. You're not going to achieve it alone. You need to have prosecution of traffickers, you need to have protection of victims, and you need to have prevention strategies. And you're only ever going to be able to achieve a combating framework of any effective force if you have partnerships between civil society and the state. In the vast majority of prosecutions that are brought, the victims don't come to the police. They come through NGOs, they come through support agencies, they come through the organisations that know how to help them and to give them support and enable their trust to be built. So I've got the definition there, but I'm going to zoom on. You all know what human trafficking is. It's an act of recruitment, transport, harbouring by means of, I call it the trafficking trap, deception, threats, abuse of a position of vulnerability, coercion, force, for the purpose of exploitation. What is exploitation? That's the profitability of the trade. It's forced labour, it's sexual exploitation, it's the removal of organs. Increasingly, it's the use of a person for criminal enterprises. So it's for drug smuggling. Drug smuggling is now captured within the trafficking dynamic. It's the use of child soldiers. It's the use of a child pirate. Before the Modern Slavery Act, we had lots of criminal laws. We abolished sex trafficking in 2003. Criminalised. We created criminal laws to prohibit sex trafficking in 2003. 2004, we created criminal laws to legislate for all other forms of exploitation, trafficking. We forgot to actually legislate a freestanding slavery offence. So whereas it had become illegal to bring somebody into the UK for the purpose of sexual exploitation or labour, if the person was found here and there was no evidential lead to how they were brought here or by whom, then there was no prosecution of the person who was abusing them. A case of mine, Patience's case, highlighted that lacuna in 2008, and in 2009 a lot of lobbying by Anti-Slavery International, by Liberty, set in place amendment to an ordinary criminal justice bill under Section 71, raised by Baroness Young of Hornsey in the House of Lords. And that became our most important piece of criminal legislation, the freestanding offence of holding a person in slavery or servitude or compelling them or forcing them to commit forced labour. Protection of Freedoms Act was important. This history is important to see where we're going to go in the future, because what we actually forgot to do in that 2003 offence on sexual exploitation and 2004 offence on other forms of exploitation, we forgot to criminalise trafficking a person within the UK or trafficking a person out of the UK. So those lacuna were filled by the Protection of Freedoms Act 2012. So finally, we were recognising a framework that was actually effective. Council of Europe Convention came along in 2005. We implemented it in 2009 on the 1st of April, and we finally introduced, it's called a national referral mechanism, which is the most important feature of recognising who is a victim of trafficking. That person not only is entitled to support and assistance, but that person could be the victim, is the victim and could be a witness in a criminal trial against the traffickers. I don't know how do I go on from that? Okay, yes, sorry, I'll just go back quickly. Modern Slavery Act 2015. This is an act about slavery, servitude, forced compulsory labour, to make a provision for an independent anti-slavery commissioner and for connected purposes. It's just new. It consolidated all of those criminal laws into one place, so a police officer can find them and can see how far the remit goes. It introduced a transparency in supply chains clause, which requires responsibilities, which I'll come on to in a moment. And it introduces, interestingly, new maritime powers to seek to combat slavery on the seas. Sorry, I managed to do it again. How do I go?
Should be on this one here.
Okay, that's one, two, one. Thanks. Okay, here we go. So section 54, briefly, this is the trafficking, transparency in supply chains clause. In short, if there's a company with a turnover of more than 36 million, the company is required to publish a slavery and human trafficking statement each year, which sets out the steps it has taken to ensure there's no slavery or trafficking in its supply chains or in its own business, or to state that it has taken no such steps. It applies to supply chains for goods as well as for services. We took this from the California Act, the American Act, but that only applied to goods. We recognised the lacuna and extended it to services. The enforcement mechanism is only a civil proceedings in the High Court that can be brought by the Secretary of State for an injunction requiring the organisation to comply. So this is still, it's a legal obligation to produce the statement. It applies to high net worth companies and not to others. Sections 36 and Schedule 2 of the Modern Slavery Act introduces maritime provisions, giving enforcement powers to ships, giving specified officers in England and Wales, Scotland and Northern Ireland new powers to investigate modern slavery offences at sea. Under the Schedule 2 powers, there are powers to stop, board, divert and detain a vessel, the power to search a vessel, to obtain information, to arrest a person suspected of committing a relevant offence, and to seize any relevant evidence. A relevant offence are those listed at Part 1 of the Act, which is the offences of slavery, the offences of trafficking, offences of forced labour. These are very new provisions, the 8th of August 2016, so we have yet to see how they work. You heard it here first. Last thing I wanted to say is that in 1937, William Prescott, a former slave who had worked his whole life on a rice plantation as a slave, was interviewed about his experiences, and he commented, "It is something, but soon there won't be anyone alive who was a slave." He worried that they will remember that we were sold, but they won't remember that we were strong. They will remember that we were bought, but not that we were brave. Today we are still fighting for the enslaved. Thank you.